Good morning. I am Judge Jeremy Fogel. I'm the director of the Berkeley Judicial Institute at Berkeley Law School. Formerly was a state and federal judge and director of the Federal Judicial Center. And I'm joined today by three terrific judges. We're going to talk about the impacts of COVID on the courts. And so I'm going to start by introducing my former colleague and still friend, Judge Charles Breyer from the Northern District of California, class of '66. Judge Michael Fitzgerald from the class of '85, district judge in the Central District of Central District of California in Los Angeles, and Judge Trina Thompson, class of '86, who is in the Felony Trial Division in the Superior Court in Alameda County. And so I'd like to welcome all three of you and thank you for doing this program.
Good morning.
Good morning.
So we're going to kind of get right to business. It's certainly a hot topic today. We did not plan it this way, but I think the impact of COVID-19 on every sector of our life and every sector of our society has certainly never been more obvious than it is right now. And there's been a very significant impact on the courts. As you'll hear from the judges, very, very few trials, if any, have taken place. Those that have taken place have been either high priority criminal trials or bench trials where there was no need to bring in jurors. But in general, the whole mechanism of having trials has ground to a halt. And the vast majority of proceedings of all kinds have been done virtually. So we're going to talk about the impacts of that, positive, negative, and what we might learn from this that we can carry forward when the pandemic ends. That we have to start thinking, I think, about what the world will look like when life begins to return to normal, because not everything we've had to do here is simply a one-off accommodation. I think there's a lot of opportunity to learn and make our system better. So let me just start with a question for each of you. And that really is, do you think there are ways that the COVID pandemic has benefited the courts, that has actually made the way we administer justice better? And I'll start with Judge Breyer.
Yes, thank you, Jeremy. Interesting. That's the silver lining, and you know, it's easy to lose sight of it. But I think that what it has done to the courts is, I don't know what the word is, start kick or force us or drag us into the present world of technology. You know, the courts like to think of themselves as being experimental, especially I think this, you know, the Ninth Circuit courts, that we are willing to try different things. But it's been my experience now almost 23 years, it's very hard to bring to effectuate changes. There is a tradition, I guess, with all of us, that what was done, we might as well continue. It's safe, it's tested, it's vetted, it's expected, it has reduced uncertainty. So the idea of changing something is generally very difficult to actually implement here, and it's a part of a process. You have pilot programs, you have endless discussions, you have all sorts of things that in order to effectuate a change. Now, I think that because of the pandemic, we've had to make these changes immediately, without the benefit of pilot programs, without the benefit of endless discussions. So let me be more concrete. A lot of proceedings that we thought must take place in a court have not. They've taken place by way of Zoom. They've taken place, I think, less effectively by way of conference calls, but we have employed technology in order to do our work. And there are a number of changes, I think, certainly in the criminal area, that will remain after the pandemic. And, we go into discussions
Yeah.
about that a bit later.
So I think this observation you made about the federal judiciary, about how change resistant it is as an institution, is certainly was my experience at the FJC, watching the judicial conference work and the rules committees. And for the lawyers who followed the process of the civil rules amendments that were promulgated a few years back, there was a big conference at Duke 10 years ago where they talked about fundamental reform of civil litigation to save money and streamline it and make discovery more efficient. And out of all of that came two very minor changes because the process was so deliberative and as Judge Breyer just said, so change resistant. And we are in a situation now where all of a sudden we're doing things that never would have been countenanced, never would have even been possible if it hadn't been for the pandemic. One very perceptive comment that I heard was from the Chief Justice of Michigan, who's been a real leader around the country in this area, and she said, "It's not the catastrophe we wanted, but it's the catastrophe we needed." It kind of got us to think about different ways of doing things. Judge Fitzgerald, do you want to comment on that and talk about
really to echo what Judge Breyer said? The Northern District of California, the Central District is this huge geographic space. In theory, I could have counsel from Needles or Blythe at the Arizona border when representing somebody who would then be represented by counsel from north of San Luis Obispo. I mean, it's not likely to happen, but it just indicates that there's this, vast area. And I've I always allow lawyers from Santa Barbara or further north to appear by telephone, and by and large, they don't take me up on it. And I can certainly understand that, especially if they're afraid there's going to be a Los Angeles lawyer present in the courtroom. But I think now that people have seen that, yes, you can do these things. And I think of, if you just were to say for certain classes of hearings, both sides are forbidden to attend in person. You have to attend by video. You have to attend by telephone. Then it just inevitably is going to save time and money for the lawyers, and let's hope their clients. On the other hand, you can't help but wonder if over time something might be lost if the I'm say the ceremonial aspects of what we do, and I don't mean that in a denigration, quite the opposite, whether those might wane, which I think would be a problem.
Right. Well, I was involved in a program yesterday with some lawyers, and they were talking about those same trade-offs that save a great deal of time and money and gain a great deal of efficiency, but they do worry a little bit about some of the more intangible aspects of interpersonal contacts. So we'll come back to that. But you would agree in general with Judge Breyer that the greater use of technology has been a good thing.
Yes, we have this beautiful brand new courthouse in Los Angeles that cost over $350 million and has built into it all of these cameras and this whole video capacity. And I don't think, maybe one or two of us was using that, and now of course we all are. And it's unfortunately not so much for the civil cases because we're limited on how many video conferences we can do at once. So we try to reserve those for the criminal cases. But I think now that, and we've been very conservative in not using Zoom.gov for judicial hearings, but that's changed as of last week. And I think now we're just, we really are just going to be doing the civil cases by video as well. And I'm sure that's something that's going to endure after, after the pandemic has eased.
Right. So Judge Thompson, your situation is somewhat different. You're in a state court with heavier dockets certainly than the federal court. You're doing criminal assignment. But what has been good about the pandemic in the sense of court administration from your perspective?
Thank you, Judge Fogel. As you know, the state courts are what we call retail justice. We see the vast majority of the community on a daily basis. And so when the pandemic hit, you're right, Judge Breyer, necessity was the mother of invention. We already had a pretty robust technology department, but it really put them to task to be creative, along with our presiding judge, Tara Desautel, and we've been able to really maximize that. We've been able to live stream our hearings so that we can maintain public hearings. We have jury trials, one on each floor, so we can have social distancing, and staff also is engaged in social distancing. Our civil departments have been having remote trials. Judge Jolynn Lee just finished one, Judge Seligman, and a couple of other judges. And on the criminal side, Judge Reardon, Judge Clay, along with Judge McCannon, who finished a trial that was in midstream when the pandemic hit. And those jurors had to come back, and he was very creative in making sure those jurors knew what to expect when they came to the courthouse, how we were keeping them safe, what the social distancing would look like, what where they could find sanitizers, the gloves, whatever it was that they needed so that they could complete the trial, along with the attorneys. And so the routine matters, I think, is probably the best outcome that we've seen from this, just as Judge Fitzgerald and Judge Breyer mentioned, is that now uncontested matters allows litigants, counsel, and ancillary parties to come in virtually, resolve those matters, not have to take time away from work, not have to be involved in traffic or parking or trying to rearrange their lives for their children. They can actually appear on these routine matters, get them out of the way, and move on with their lives. Technology is going to be a big part of curriculum in the future. We're already doing this on the undergraduate level, and I'm certain at the law schools now, that is going to probably be something that's going to be integrated in. And it's a time for attorneys to be very creative, but also they have to make their record.
Right.
This is the time where attorneys are going to have to be exceptionally judicious and really do a lot of research and make sure that they make the implicit explicit, because when we get further down the road, we'll look back at this time to see what really worked and what didn't work. Yeah.
We're going to come back to that, how we evaluate what we're going through now. It's kind of hard to do it while you're doing it. But I know you're in a felony department, but something I've heard from a number of judges in state courts around the country is that in some of the real high volume parts of the trial courts, evictions, debt collection, misdemeanors, that actually people are showing up who didn't used to show up, that the failure to appear rate has gone down significantly, that people actually come to the debt and eviction proceedings to defend the case. Even if they don't have much of a defense, they still come. There's still a process that didn't exist before, and where there might have been a default before. Has that been the experience in Alameda County as well?
That's been the experience here in Alameda County as well, because it does provide additional access. And like I said, it reduces that that tension that people feel of whether I need to go to work or whether I need to handle this, because, you know, they're essential workers. They don't have the kind of benefits that will allow them to take the extra time off. They've used their family leave, what have you. So I do see an increase, but those are for individuals who have digital access. When the libraries and other places reopen, I think we'll see a broader use of these platforms for people who are in indigent portions of the community. But I think we have to also take pause and realize that there are unspoken voices that aren't being heard because they don't have access to the technology or the bandwidth. I mean, we've had litigants saying they're in the parking lot of, you know, McDonald's or Burger King in order to get a hotspot. So it's things like that that we're still having to take a really close look at to see if we're excluding a group of people.
Right. No, that's really a good point. It's not just indigent people either. There are parts of the country where just like I was at a hearing where we with one of the members of Congress who was there is from Alabama, and she was saying there's a big part of Alabama where they just don't have enough Wi-Fi. You know, there's just not enough bandwidth, period, for people to participate in online proceedings. I hadn't never thought about that, but it's kind of a.
And we're going to see that more because of the California fires, and I think people need to be aware of that as well.
Right. So what I'm hearing is that the positivity is greater access, saving people time, saving people money, streamlining. I've heard from judges they have more time to do other things because they're not is involved in as many live hearings, certainly for lawyers. What are some of the negatives? What are some of the things that have really been detrimental to the system as a result of the pandemic? Let's go back to Judge Breyer.
Well, Judge Thompson actually raises a very good point. When she says they do retail justice, that may not be, that certainly isn't, it doesn't do it justice, because the volume, the magnitude of state court proceedings, and I've never been a state court judge, but I do have some appreciation, is enormous. And it's important that numbers matter. And process matters, and I think that Alameda County's done a great job. They are innovative, they are energetic, they're professional, and maybe they're Bolt or Berkeley Law School trained. I'd say Bolt because I graduated in '66. But anyway, I wanted to make this point. Because you asked about downsides. One downside is that while we say, as you just did, it provides greater access to the courts and to the functioning of the courts, the question is by whom? Is it equal access? Is it access to people who don't have computers or or technologically impaired, or simply just not doing Zooms and don't go to one part of their house or office or whatnot to participate in a telephone call or a Zoom meeting? And that's a serious concern because a lot of the people that we see, and many more that Judge Thompson sees, are people who are indigent, or people who don't simply have the resources or can't devote the resources to access to the technology. And I think that's a downside. And I think we have to be very, very careful about making sure that we provide equal access to justice. Another downside, which I don't know yet, because I've yet to have a criminal jury trial, is can you get really a cross representation, a fair representation for a jury pool? Because you are eliminating, we are, and I guess Judge Fitzgerald's doing as well. If somebody feels they're particularly vulnerable to COVID, they're out of the jury pool. I mean, we send out this questionnaire, and if you take care of somebody your age or something, and you have some reasons, it's like any reason relating to COVID, you're out. So we've eliminated a whole group of people from consideration for being included on a jury. That's an issue. That's a serious issue. I've not done it yet. I plan to start up in November, but I don't know, maybe Judge Fitzgerald or Judge Thompson has some experiences in those areas. I'd be very interested to hear what they are.
Yeah, and I want to talk a little bit more about jury selection, but you're just talking about the pool of prospective jurors in the first instance, that it's been skewed as a result of COVID. Judge Fitzgerald, any comment on that, or anything else you think is a negative here?
Certainly what Judge Breyer just said, I don't think we've released this publicly, but I'll just say we did send out one jury summons, and then after the July 4th spike and the concerns and the governor's putting in the new, orange, red classifications for counties. We recalled those, but we had gotten enough returns to try to get a sense. And without giving specifics, I'll just say that there were fewer people were bothering to even return the summons than would have been the case for the same, the year before for that same week. And moreover, for those who, who did, there were a certain percentage said, so a small percentage, but a certain percentage said, I'm going to ask to be excused and for these reasons. And then a certain percentage just said, I know this is mandatory and I'm returning the form out of respect for the court, but I'm not going to show up. I mean, I'm just not. So, don't on this. And obviously everybody who didn't return it was doing that. So it was kind of, I don't know what Judge Breyer was saying. In order to get a cross section of the community, at some point there has to be the sense that jury duty is compulsory. We don't send out the marshal to arrest people, but in the back of everyone's minds, that of those summoned and the court, there has to be at least that's an option, or that's sort of the paradigm under which we're working. But as it is, we're really letting people decide for themselves whether to come, and who knows what group of people that's going to be. I think the other downside is, obviously for this period of time, we haven't had jury trials. So and those are what is, are supposed to be the engine that is driving the system in both civil cases and criminal cases. And my concern ultimately is that of how much work there is to do, how much of our jobs are going forward without that. And, we do think of ourselves as trial judges. We think of ourselves as trial lawyers. We just don't think of ourselves, we think that we have these great jobs as lawyers or judges. We don't think of ourselves as, people, litigators who could have been corporate lawyers but aren't and don't make as much money. Or we don't think of ourselves as, judges who just read and write, but we aren't on the Court of Appeals. We think of ourselves as having this unique and very special job, which in some ways is more, part of the lore of the law in American culture, and just a more interesting job than, say, somebody on the Ninth Circuit or somebody on the First District Court of Appeal. And whether or not that's true, until now, it's been easy to tell ourselves it's true, but now that's been sort of stripped away, and it's unfortunate.
Well, you make a really important point. I think I was talking with a trial judge from Florida yesterday who was saying that in managing pretrial proceedings, the motions and the status conferences and all the other stuff that trial judges do, there's always the prospect of the trial at the end of the road. And so, most cases actually end up settling, or the motion practice resolves them. But the fact that there may be a trial is the driving factor. It's the underlying reality in the way that cases are managed. And if you can't say that credibly, if there aren't any trials, it changes everything. It changes everything that happens further up the pipeline. And I think that was, you were really implying that in what you were saying, that it's changed everything else you do.
Right, but it also it's done two things. That for this period of time, it has done that, and there's going to be a huge backlog and reckoning later on, which is scary. But since so few, like I mentioned to the panelists, I have offered in all bench trials to keep the trial date and to conduct it virtually. And I have also offered to anyone who wants to waive jury and proceed in that fashion to do that. And no one has taken me up on that. So clearly there's going to be this big crunch later on. But like I said, even more than that, it's just concern that this illusion of being trial judges, trial lawyers, going to court that we all tell ourselves all the time has been stripped away in a very unceremonious fashion, and I just can't help but think that it's unfortunate. You know,
Right.
when I took this job, I wasn't taking it to just be a fancy law clerk for the Ninth Circuit. It's just
Well,
you
they
know,
may see that differently. I don't know.
yeah,
But
but it's just unfortunate that this has
Yeah.
revealed how little the actual trials are a part of what it is that we do.
yes, no, that's really important. So, Judge Thompson, you've been doing some trials in Alameda County. So I want to go back to the question about jury composition and get your thoughts about that. And has the pandemic changed who you get in the jury pool?
I'm glad you asked that question, because some things that I think are not as obvious to a lot of people is that, for example, Alameda County is exceptionally diverse. There are probably 25 different languages that are spoken in Alameda County. So you also have the challenge of those who may have a language barrier, as well as a barrier from technology. And anyone that does criminal trials in a state court knows that jury selection is the most arduous part of the trial. It is the most labor intensive from our jury commissioner on, and our jury commissioner might send out 1,000 jury summons, and we might have maybe close to about 300 people out of that suite that physically show up. And then from that number, then you have the hardships that immediately are eliminated, because if they're 70 and older, they don't have to give us an excuse. They can just say, I can't serve, I have a medical impediment, or they don't even have to tell us that because of the way the California rules of court are structured. This is my 5-second pitch to our legislators. They do need to re-examine jury service and what we do. I believe the rules for jury service in terms of how much jurors get paid is probably about 75 years old, of $15 a day. And so either they need to up that ante, or they need to have a conversation about how to make it so that employers will allow their employees to serve on these different juries. And cases I have last a month, 2 months, sometimes half a year. And so the other things that we did not consider as we begin selecting juries is when we send out the subpoenas for witnesses. If a witness is COVID positive, they might have to have a 14-day quarantine. If there's someone who lives out of state, they're going to need a 14-day quarantine. If there's someone who's abroad, we may not even be able to get them here because of travel bans. So as we began trying the cases and began scheduling them, we found that we were in abeyance because there were some things that we hadn't contemplated that would be an impediment to getting started. So you might tell a juror, we think this trial is going to last 3 weeks, but because of some unknown issue, it might take a little bit longer. So jury service is already difficult for essential employees who work in areas that hardships are at an all-time high for them, either because of health-related issues, families now living, kind of consolidating because of fires, because of loss of employment. And there's all of these very organic things happening, and it's not static. And so we're trying to pivot with everything that we're seeing, and it's impacting the cross section of the community that we're seeing in jury service. And it tends to have a certain demographic look, and it's ages probably 30 to 50, people who have tech jobs or engineers, or so that is going to be an issue, and attorneys will need to really think through how to ameliorate that issue.
Yeah. So it is affecting even in the state.
Let me add, if I
Yes.
may, add something to what Judge Thompson said about the that. Well, actually, I think it was Judge Fitzgerald who said that that he misses the ceremonial aspects in the good sense. That is, that it conveys a sense of dignity and so forth. There's another aspect of that, which is evident when you need to sentence a criminal defendant or take a plea Those are two areas that I think are particularly sensitive. And if you are going to do it by way of Zoom, and I've done it by way of Zoom, it sometimes is, I'd say, deeply flawed. And it's flawed because you don't get a sense of the person standing before you. Now, you can say, well, you know, it's a close-up. The defendant doesn't have to wear a mask and so forth. Usually the defendant is not in the same Zoom room or whatever it is, the room with the defendant. His lawyer is not there. You're trying to read what I think are any number of subtle signs that I think Judge Thompson, Judge Fitzgerald, and you, Judge Fogel, have seen over the years. You know, how is a defendant answering a question? The words on the written page don't necessarily express the not just the emotions, but the process that's going forward. It's all that an appellate court may look at, but it's not what you look at as a trial judge. You get a sense of how voluntary is the plea, how knowing is the plea, what really are the circumstances surrounding this particular defendant and the offense that are relevant to your considerations for imposing a sentence. And a lot of that, or at least some of it, I don't want to exaggerate, but at least some of that may be lost by the absence of a defendant standing in front of you. So that's, you know, I must tell you, I was given the option. I was given the option as of either conducting hearings in a courtroom that was specially outfitted for COVID concerns, which is shields and masks and distances. I did it over 2 days. And I must say, like the defendant, I thought the defendant was like 30 feet away from me, behind a computer, wearing a mask, all of which I understand from a COVID point of view, but many of which are impediments to actually our doing our judgments. You know, I mean, we're not put on the court. Anyway, well, that's my point.
No, that's a critically important point you just made, I think, and it's shared very, very widely by judges I've talked to everywhere. There's a couple things I want to follow up on. There was a question actually from one of our audience about bail hearings, and it really goes to the point that Judge Breyer was just making, that are bail hearings done virtually? And the evidence, and there is evidence starting to be gathered about this, is that defendants get detained more often after virtual hearings than they do after live hearings.
Oh, yeah, interesting. What is Judge Thompson's
I was going to just ask Judge Thompson, what's been your experience with that?
Well, in Alameda County, we had a strike team, and I was part of that, and we literally went through the dockets of every single defendant that was housed at the Santa Rita Rehabilitation Center in Dublin. We found anyone that was considered nonviolent and non-serious, they were released on their promise to appear, just blanketly, that people were getting released because of the COVID outbreak. Then hearings were being held in which the attorneys here in Alameda County, some opt to sit in the room with their clients where they might have some distance between them, they have their mask, and we're able to see them in a courtroom that is set up just for the attorney and the defendant. When I'm on the bench, I wear a face shield so that they can see my expressions. If my staff is social distance, and what we'll do is one person might be in one room and I'm in chambers with my robe, and so that we can at least be able to have some connection to the person. And so far, from what I can see, more people have been released than detained under this procedure. So far, I mean, we're using pretrial assessment tools. We're even doing this when we are on search warrant duty, people who are getting arrested, and we might see their assessment and we're able to make some decisions that way. And then the attorneys weigh in if their release is denied, and there's conditions that are attached to their bail or to their release.
I want to follow up a little bit more in this jury area that we were talking about before. Another one of the controversies that's arisen is that even if you decide to go forward with the jury trial, or you're able to go forward with a jury trial, there are decisions you need to make about what you're going to do for COVID in the courtroom.
Yes.
Certainly, with witnesses wearing masks raises confrontation issues. But specifically about jurors, there's seems to be a no uniform practice among trial judges about whether during jury selection the jurors should wear masks or not. And some judges think it's inappropriate, some think it's appropriate. So I'd like to get your thoughts about that. I'll start with you, Judge Thompson, because you've done it more. What's your practice and why?
We've tried to be as consistent as possible, but as you know, each judge conducts their courtroom slightly different than maybe another judge because they've had some experience and they find that it may be easier. But the standard way is that jurors are allowed to come in with their mask. They approach a podium that's in plexiglass. They can take their mask off in order to answer questions so the attorneys can kind of see what's going on. In my courtroom, I make sure that the shields are available for everyone. This comes off, the plastic comes off, so that becomes that person's, they own that afterwards. I don't worry about trying to clean them and all of that sort of thing because they're disposable or replaceable. And we ask the attorneys to do the same for their witnesses. We ask the attorneys to bring their own PPE materials for their witnesses. Their witnesses have a staging area where they wait. They wait in the offices holding waiting room, and then they're brought to our floor, and then they're brought into the courtroom. And so that seems to be working, and we rearranged the tables in the courtroom so that the attorneys are also have distance from one another. As you saw from the pictures and the materials that I provided you, we have the seats are designated where people can sit, where they cannot sit, and jurors are spaced out in the courtroom. I've talked to some attorneys who are in the South or who are in the Midwest. They've even told me about using their fairgrounds or using a gymnasium or a school that's not in session. And they have the jurors in the middle of the room. So the jurors can see everyone as they're doing the presentation. And then we have evidence presentation monitors so that people have a clear view of everything that's going on. So and each judge has their own materials to clean after a witness has testified. And I have to tell you, egos have to go out the door because everybody's on board in keeping the courtroom clean. So you will see a judge get up and wipe down a surface, wipe a microphone, and no one's trying to be ego invested because we're all trying to be safe and we're all trying to make sure we get through this without anyone getting sick. But it does help to have all of this planned out well in advance. We also have a separate courtroom where the jurors deliberate. They don't deliberate in the same room where the trial is going on. They don't go to a deliberation room. They actually have a dedicated courtroom where they have that space and it's properly marked for their deliberations. So you have to do a lot of planning. You have to make sure that your colleagues are mutually cooperative with one another. And that we all realize we have a lot to learn from each other. And sometimes the attorneys come in with some amazing suggestions because they've had to do it in their own law offices as well.
Let me pivot a little bit to talking about attorneys. I think this conversation about jurors is just fascinating, and we could talk about it a lot more. One of the things I've heard from lawyers is that they really like having more time. They really like having more efficiency in their calendars. But one thing they don't like is the opportunity to interact with each other in informal ways, when court's not in session, when it's like just a chance to get to know your opposing counsel or get to know your co-counsel, or even to get to know the judge, to just get a sense of who you're dealing with on a personal level. And they feel that somehow the virtual world flattens that. It kind of prevents you from developing those kinds of relationships. So I'd like to ask, and I'll start with you, Judge Fitzgerald, have you felt that? I mean, do you feel like you've lost something in terms of the human interaction you have with counsel?
I think that that's a real concern. You know, especially on, I've been willing to have telephonic conferences in civil cases if it's just some minor dispute, you know, rather than have people brief it or brief it further, rather than have them show up. It's just easier to get people on the phone and just, you know, get it done, you know, whether a hearing date should be postponed by a week or 2 weeks or something, you know, like that. But I had been in the habit of having the scheduling conference and then an early status conference in my criminal cases take place in the courtroom, and I required people to attend unless they were from Santa Barbara or further north. And it was at the advice of some of my older and wiser colleagues who said, that way they know where they know where your courtroom is. You know, they don't go to the wrong courthouse. They don't go to the wrong floor. They have met opposing counsel in person. Maybe the case will settle when they get a cup of coffee afterwards. And I think that I thought there was a lot of wisdom in that, and I've just seen that. You know, I'd rather have somebody be late because they don't know where to park, or they aren't sure how to get into the new, or they forgot that there was a new courthouse in downtown LA and they went to the old Spring Street courthouse or something like that. I mean, better for this scheduling conference, which ultimately doesn't really matter that much, than for a summary judgment hearing, or, you know, something like that, where their client would be there and they'd be embarrassed. And I do think that the fact that we don't have things like that, especially since right now, and I do hope in the next few weeks it's going to change, all of the civil hearings are telephonic, and they aren't even, you know, they aren't even, you know, video like we're doing here. You just can't help but think that it's a certain loss.
You've lost it.
The lawyers.
Judge Breyer, what do you think? I mean,
yeah, well, actually, you're the master of alternative dispute resolution and case management conferences. That is, how do you organize? How do you process a large volume of litigation in order to achieve, as the federal rules say, the expeditious, quickest resolution of the problem? How do you do that? And what I've learned from my colleagues and what I've learned from years on the bench is that the case management conference gives the judge the opportunity to determine what is the problem in the case. Why is it a case rather than why, you know, where did the breakdown occur? Why is it necessary to involve the court in resolving the dispute? And what I found in case management conferences, and I think my colleagues would second this, is that it may look like a problem going in on the papers, that the parties disagree as to this or agree as to that. But once you get them to talk about it, you see, is the problem that you have to resolve an issue of law, that the client is unreasonable, that they haven't really pursued alternative dispute resolutions, are there other ways to approach it, and so forth. That's the dynamic of a case management conference. It's not its structure. It is what comes out of its structure. And my concern is that if you start to do it remotely, or as and we have to do it remotely now, large part, but will it become a permanent fixture? And I'd say there are trade-offs there, and you have to be very careful about losing the intangible dynamic of being in a courtroom where you could have these types of discussions and change your mind. By the way, I change my mind all the time. We all do. Good judges change their mind when they see a different approach is going to be more productive. And I think you might lose that, and that's a concern that I have.
I'll just weigh in. I'll just take my moderator hat off for a second and put my teacher hat on for a second. I've always believed that status conferences, case management conferences, can be extremely valuable for just the reasons that Judge Breyer was describing. Doesn't mean that every single one of them should be in person. I think that is not fair to the lawyers. I mean, sometimes to just come and, travel for 6 hours and then have 5 minutes of the judge's time just to get a new date, that's not very helpful. But the kind of interactive process that Judge Breyer was describing at the beginning of a case, I mean, the judge gets a sense of the case, the counsel get a sense of the judge, the counsel get a sense of each other, and you really sort of build a problem-solving culture within each case. I mean, that's always what I think is the paradigm. And I think it's harder to do that using a medium like Zoom. It's just flatter, it's like, and people get distracted, particularly if they're working from home. Things can happen. The dog starts barking, or the kids need help with their schoolwork, whatever the situation is. So you do lose something of that in-person contact, and I don't think that it's something that ought to happen in every hearing all the time. And we're going to talk about what to do going forward in just a second. But there is an intangible, I think, that you gain by being in the same room together, and also what happens afterwards. It's when the lawyers go outside and maybe they don't know each other, maybe they don't have a pre-existing relationship, and they've met and they have a chance to chat and size each other up. So I think that is something we've lost a great deal of. Judge Thompson, I haven't asked you about this, and you're managing a heavier docket, and you're managing criminal cases where you have repeat players by definition, public defenders and DAs. But what are your thoughts about this, about the sort of the human dimension?
A lot is lost. We do have what we call breakout rooms, and I'll ask the attorneys to arrive early so that my clerk can put us in a breakout room and we can have an in-chambers conversation, but it is flat. If I have someone who's less experienced, trying to kind of mentor them through the protocols of the courtroom, how to deal with our deputies and making sure that things run smoothly, how to work with our courtroom clerk, how to get things filed, how to use electronic presentation of evidence, publication, and all of that, making sure they've set their foundation ahead of time. And you want to do that in chambers because you don't want to do that live stream, because that could be very insulting to an attorney who's just starting to get their sea legs, or someone who is just overwhelmed by just the emotion of having to handle a case in this environment. So there's a lot that gets lost. You don't get to do as much of the mentoring as you'd like to do. You don't get to see the attorneys develop some mutual respect for one another and allow them to be as vigorous as they need to be. But the other part of it is, in criminal cases, unlike civil, where it's all a dispute over money, we're talking about people's lives, and we're talking about their liberty, we're talking about their freedom. And if an individual's in custody, their entire family's in custody. If a person has been victimized, their entire family's victimized. So there's a lot of emotion. And just as Judge Breyer said, we're used to having people in the courtroom where we can see and assess and evaluate, and the trier of fact in particular needs that kind of interaction so that they can really see and test whether someone's credible or not, whether someone's genuine or not, whether someone's remorseful, whether someone is feigning or malingering. All of these different things, or if they're playing off of someone in the courtroom, or if they're being coached, all of these intangibles that make the virtual platform a larger challenge in criminal cases, unless it's a bench trial, or civil cases where there's a lot more that you can manage and a lot less emotion, unless it's like asbestos or some highly charged emotional case. So these are all things that we're grappling with on a daily basis. I know I'm constantly doing this constitutional law balancing test of how do I not invade on someone's individual rights, come up with a least restrictive alternative so that we can resolve some of these cases, people can have closure, but also get ready. There's a tsunami waiting on us. Because while the attorneys are enjoying this period of time of having a lot of time to prepare, there are people waiting to have their cases resolved and have their lives move forward. So,
yeah, and that's a great segue into our last segment. We have about 10 minutes. So what I want to ask each of you is, let's think ahead. We don't really know when it'll be safe to return to something resembling normal life, but whenever that is, I mean, let's assume it's optimistically 6 months from now. What should we keep from this experience? What have we gained in terms of knowledge that would make our system better, and how would you implement it? And I'll go to Judge Fitzgerald I'll start with you on that. What do you think is worth saving from this experience?
I think that for certain law and motion matters, allowing the lawyers to appear by video or by telephone, I think it wouldn't be, they wouldn't be losing that much. I wouldn't be losing that much. The court wouldn't be losing that much. And that would definitely be something that we could try to help them out. You know, the other thing is, again, since we're just moving to video for civil cases, but or even for some of the criminal cases with the sentencing, it could potentially be something between allowing television in the federal courts as just kind of just an all or nothing. But if there were witnesses on the East Coast, or I mean, if there were victims on the East Coast or family members of the defendant, and there'd be a way to increase participation beyond those who are physically able to attend in the courtroom, without saying that, well, we're just going to allow television in the federal courts the way it is.
What do you think about in criminal matters, not adversarial proceedings, not where there's actually going to be testimony or anything like that, but calendar management proceedings? I think we've already talked about bail's a little different, but let's say the defendant is either in or out of custody, and it's not a trial, it's not a motion hearing, it's some type of status conference or scheduling. Do you think, how would you feel about those being virtual, assuming that the in custody defendants could have adequate technological access?
Which they have, so we could continue with what we're doing. It would, in part, it's going to be whether the Marshal Service continues to get budget cuts, because at some point they're the ones who are responsible for having the in custody defendant show up in my courtroom, and it's a huge and expensive operation to do that. I think the real issue is whether the guilty pleas are going to continue to do this, because they're very time consuming. Judge Breyer has very eloquently explained why, in the best of all possible worlds, it would be taking place in a courtroom. On the other hand, for someone who's in custody, to bring them over from the jail does sort of things. So I think I'm of two minds on whether I would continue in certain cases to have, obviously if the defendant was willing, to have the guilty plea be be by video instead of in my courtroom. I think that there's advantages and disadvantages. It's going to be a difficult thing. I certainly would want sentencings to be in the courtroom, unless there was a very good reason not to do that.
Judge Breyer, what would you preserve?
Well, I follow Judge Fitzgerald's lead. I think he's right. He's identified the easiest answer is, of course, routine matters, and you have to be careful how you define routine. But routine matters where you're simply going to have 5 minutes of setting a trial date, or the next status conference with an instruction, go do this, go do that, to drag somebody into court at the expense and so forth may not be a good idea. I think it's a bad idea, and I think that we can take our lesson that we've learned from this. Now, I would still, and that's perhaps because I'm too fixed in my ways, but I think there are reasons for it, want a plea and a sentencing to be in front of me. I just see too much or not enough of the dynamic, and I think that's important. But what is really interesting was exactly what Judge Fitzgerald says. Look, maybe we can use television in cases where we have to introduce testimony and so forth. I would go a step further. I have always been an advocate of cameras in the courtroom. And I have been told, and I go back to when I was on the Judicial conference and so forth, I was told, look, that's going to be like the end of the world. we're going to have, I mean, it's almost like King Lear, and you know, he's going to do such things. It's going to end our process. It's going to be the end of the judiciary as we know it. And the answer is, guess what? It hasn't been the end of the judiciary. People have been, a lot of proceedings have been Zoomed, and it hasn't resulted in widespread a misappropriation of what goes on in a courtroom. Now, I'm not saying that there ought not to be safeguards, but I do think that we might want to rethink this, because there's a flip side, a good side to it, which is transparency of what happens in a courtroom, and it educates the public as to what happens in a courtroom. We don't do our job in secret. The courts do it it's a public process, and it educates the public, and it brings within it, I think, acceptance of the judiciary. When you think of our branch of government, it's so small compared to the other branches of government, yet it is so vital to conducting the daily affairs of life in our government, in our lives, that it's important that people buy into it. My view is that this is given a window into the of opportunity.
I think that's well said, and I think it's an important takeaway. Judge Thompson, I'm going to give you the last word. Your thoughts as to what is worth preserving going forward.
Okay, well, I'm probably that word of caution. I think that as Berkeley alum, we are collectively some of the best minds in the state, and hopefully we'll be on the right side of history. As a public servant, I get really nervous when we start talking about too many shortcuts. The power of stipulation for the attorneys is a very powerful tool, and that can make sure that there is equity when we are trying to streamline some of this. I do think that the uncontested matters, routine cases where it's just a matter of formalizing something that's already been agreed upon, that those are the cases that definitely we can surrender to that. When we talk about kind of televised proceedings, I get worried about performance error. I get worried about people deciding that, oh, the way we've done things is too cumbersome. But to make a complete record, it may seem cumbersome, but this is the only way we can ensure equitable outcomes under the circumstances. We shouldn't be too quick to take shortcuts. No one wants to make a fatal mistake or be the catalyst of an irreversible outcome. So I think that as long as we keep, just like when we're in family law, we tell people to keep their kids in the front of the litigation, that they always have a picture of their child so that they're not quarreling with the person on the other side of the table. I think we need to keep the Constitution in front of us. We need to keep in mind that we are public servants, and but for the public needing our help, we wouldn't have these jobs. And so, we have to make sure that we do embrace the public in every way possible, and that we really do look at those who need access and fairness and access to our courtrooms. And so if we can accomplish that, that's great, but don't be too quick to make too many broad sweep changes without thinking about the outcomes.
Yeah, well, and I'll just add, I think what you've said to me suggests the need for really thoughtful study about what we've been going through. In other words, right now we're in the middle of it. I mean, people are just trying to figure out how to deal with the wave, and try cases so that people don't spend years in custody and that type of thing. What we haven't done is we haven't really done the social science and looked at, what's it like for the litigants? What's it like for the judges? What are those interactions like? What are the changes in the composition of jury pools? And there's a real place for scholarship here, I think.
For sure.
And until we have sort of a little bit of a reflection on what's going on, I mean, we're speaking from inside the experience rather than looking at it from the outside. And I think everybody, all three of you, have raised important values that we need to keep in mind. But I don't know that we have a lot of data yet as to what this experience has actually been like for the people who've been going through it. So I think with that, we have exhausted our allotted time. I do want to just take the last 30 seconds to thank each of our panelists. They're they were on this panel for a reason, and not just because they're Berkeley alums. It's because they're really terrific people and terrific judges. So it's great to see all of you again, and I hope that this conversation was valuable for the people who listened to it. All right, thank you.